So I have the great honor, as the new co-chair, of introducing our main speaker, Jim Santelle, who served as a criminal prosecutor and civil litigator for 30 years for the U.S. Department of Justice, and for more than 6 years as the U.S. Attorney for the Eastern District of Wisconsin. That means he was the chief federal law enforcement officer for the 28 easternmost counties, including us. Most recently, he has continued to work as a trial attorney in both state and federal courts, litigating all kinds of cases: housing, employment, family law, prisoners, and civil rights. He regularly teaches and speaks on issues related to the operation of government, the promotion of justice, and the rule of law. And he's with us today to talk about the limits of presidential power. Jim, thank you so much.
Yep. Nancy, thank you so very much. What a great honor it is to be with you today on this very distinguished panel, also seated with me. And I want to thank you so very much for the invitation that you have extended to me to be with you, to share with you some thoughts about where America is today, both in the state of Wisconsin, in our region, and also nationwide. We have a limited amount of time today, and in fact, in America, time is fleeting, so let's get right to it. I'm going to spend some time today talking with you about some things that have happened just in the past week in the connection with federal district court judges. I'm going to talk with you a little bit about some things that the Supreme Court has done. I'm going to talk with you about what your Attorney General in Washington, D.C. is saying, what your president has said and announced about the rule of law and the prerogatives that he believes that he has, and then indeed, pursuant to the commission given to me by your leadership, we're going to be positive about this as well. And I'm going to talk with you about some things that you can do today and tomorrow, in addition to the wonderful suggestions already made by our colleagues here today. Let's begin right away by talking with you about some things that have happened just in the past week. The first thing you should know, and the reason you should be excited about America and the state of Wisconsin to this day, is that there are bastions of liberty, and there are rule of law standards that are being upheld. And the word, the concept, the structure are federal district court judges. They're the ones, they're the guardrails right now that are standing between the oppressive and, yes, illegal and unconstitutional things that our president, that my president is doing. You know that there are about 50, I counted just this morning, actually in excess of that, 50 judges around the country who have already said to this president, no, you cannot do that. You know the kinds of things that have been out there. Everything from suspending grants to ensuring that much important and needed monies are given, to ensuring that everything from rights in America and in our states are upheld. Let me tell you about two of them that happened just this past week. There's a federal district court judge in San Francisco. Her name is Araceli Martinez-Olguin. She is in San Francisco, and on Tuesday of this week, she ordered that the Trump administration restore legal aid to what? To thousands of migrant children, about 26,000 of them in our nation, nationwide, who are in the United States without a parent or guardian. There is a law that provides that indeed, when it comes to representations in the federal courts, and with respect to immigration in particular, that there is money allocated to ensure that they are represented in our courts. This past week, Judge Martinez-Olguin said to the president, no, you cannot limit the expenditures of those monies, and directed the administration to restore that representation as a part of the Constitution. That was on Tuesday of this week. On Thursday of this week, another judge, Mary McElroy, she is in the District of Rhode Island. She also is a trial court judge. And on Thursday of this week, she barred the Department of Health and Human Services from stopping a whole cadre of federal public funds that had been allocated by the Congress during the COVID-19 pandemic, but continuing to this day to do what? To provide critical health services to entities and to communities around the nation. That judge's action there in Rhode Island, that judge's action in San Francisco ensures that the rights and privileges under this thing we call the Constitution of the United States of America are upheld. And it also sends the message to all of us that legislation has meaning. And so, for example, when the Congress allocates $11 billion with a B dollars in health grants and says to the executive branch responsible for executing on that, that has to happen. Those two things happened just this past week, in addition to the 50 or so other judges who have entered injunctive relief orders commanding that this president, that this administration not pursue the kinds of things that he and others want to pursue. Let me talk about what happened this past week with respect to two other judges that are also federal district court trial judges in America. You know well the basis, the predicates for what I'm about to talk about, and that is in particular the issues related to the Venezuelan immigrants, right? We know that about 3 weeks ago, actually on the 15th of March, this administration rounded up somewhere around 100, maybe 150, maybe 250 Venezuelan immigrants and placed them on 2 to 3 planes, C-130s, and transported them to El Salvador, where they stay to this day. On that same day that happened, and we'll get back to the question about exactly when that happened, a federal district court judge named James Boasberg, B-O-A-S-B-E-R-G, he is the chief judge of the U.S. District Court in the District of Columbia, had a hearing. And people came in on behalf of those immigrants, the families of them, and said, "Judge, we think that the law under which the president is attempting to do this is not applicable, and beside that, they have not been afforded what? Due process under the law." And so what Judge Boasberg did 3 weeks ago yesterday, on the 15th of March, he told, just like all of those other judges, he told the administration to stop it, to knock it off, to keep those planes either on the ground or if they're in the air, send signals to them to bring them back to America so that those people who have not been afforded due process have that due process. And here's your additional civics lesson for the day. I know you all know this. I know our representatives here know this as well, but it's important to reaffirm it. Under our Constitution for 238 years, the privileges, the prerogatives, the protections of the language of our Constitution are extended to everyone who is here geographically. It is not limited to simply citizens of the United States of America. Equal protection, due process, that is afforded to all people who are here. That is the glory and that is the wonder of our nation and our state. And if someone tells you that somehow Venezuelan immigrants or other people who are not citizens in the literal sense of the word do not have the protections of our Constitution and our laws, you tell them that they are wrong. And that for 238 years, beginning with James Madison, we have maintained just the opposite. And so Judge Boasberg, 3 weeks ago yesterday, said Donald Trump, Department of Homeland Security, Department of Justice, for which I worked for 30 years, and others, bring those planes back, and if they're in the ground still, on the ground, do not let them go. And in the wake of that, for the last 3 weeks, Judge Boasberg in his district court there in the District of Columbia has had multiple hearings and motions and pleadings and arguments about whether or not his order, his injunctive relief, his order to the president was followed. And for the past 3 weeks, your Department of Justice, my Department of Justice, led by Pam Bondi, who is our Attorney General, has not provided the judge with any information about when those planes left the air, when they landed in El Salvador, who was on the planes, and importantly, what the status of those 200 or 250 people entitled to the protections of the government, what their status is. And he has asked them repeatedly for information that we know is there. The question, quite simply, is just this. If Judge Boasberg issued his opinion at 6 o'clock on Saturday, March 15th, when did the planes leave? Did they leave before that? In which case, all right, we need to know that information. We may still ask them to come back. But if they left after that, that is called contempt. That's called contempt of court. And for 3 weeks, Judge Boasberg has attempted to get information from the Department of Justice about whether or not those planes left in violation of his judicial order under our system of rule of laws that commands that the executive branch do something because the judicial branch is empowered by our Constitution to do just that. And so I'm going to go into this in some detail because it is chilling for me as a former United States attorney, a former assistant United States attorney for 25 years who stood up in the courts of this country, including right down the street here, and consistently followed the directions of a federal district court judge, even if that judge says to me, Mr. Santelle, you are wrong, you need to do something else. This past Thursday, Judge Boasberg had one of the most chilling hearings in the history of our nation. Judge Boasberg called in the Department of Justice, and in particular, he called in the Deputy Assistant Attorney General of the United States of America, a high-level litigator. His name is Drew Ensign, E-N-S-I-G-N. I'm giving you his name because I'm going to recommend later on that you write him a letter and tell him about what you think about his conduct. Judge Boasberg asked Mr. Ensign, who is representing the government, he said this: "You maintain, Mr. Ensign, that the government was in full compliance with the court's order on March 15th, correct?" And Ensign responded that he believed that was the case. That the Department of Justice did comply with that order, and the judge said this: "These are not good words if you are a litigator appearing in federal court." He said, "It seems to me that there's a fair likelihood," and that's the language that was in all of the headlines of just the past several days, that is not correct, representative of the Department of Justice. In fact, the government acted in bad faith throughout the day. There is more. The judge said, "I'm going to get to the bottom of this." He said, "I think the representations, the statements you're making on behalf of the Attorney General, on behalf of the people of the United States of America, are sketchy. I do not believe them." And here's an exchange between Mr. Ensign, representing you and me in the Department of Justice, about what the department did with those planes and what they knew and who was responsible. Ensign responded to the judge's specific requests for information by saying that he thought he sent an email to officials at the State Department and the Department of Homeland Security about this. He thought he sent an email about this. He admitted that he alerted some low-level Justice Department people about what had happened in federal court, and he said he couldn't recall if he had told anyone else at the department, including the Attorney General of the United States of America, who was certainly monitoring what was going on, about what the judge had done. Ensign said he had no idea who had allowed the planes of migrants to continue on their way to El Salvador, provoking an incredulous reaction from the judge, who said this. He said, "Who made the decision either to not tell the pilots anything or to let them keep going in the air?" And Ensign, on behalf of you and the Department of Justice and Pam Bondi, said, "Your Honor, again, after 3 weeks of preparation, information known to the government, your government," he said this: "Your Honor, I don't know that." The judge said, "You're standing here telling me you have no idea who made the decision to not bring the planes back?" And Ensign said, "That was the case. I do not know those operational details." I would offer to you that that is a stunning representation for the Pam Bondi Department of Justice to represent on your behalf in a federal district court after 3 weeks of inquiry to a judge who has the power and the right to ask those questions. There is more. The judge asked, and this is the part that needs attention because things are going to happen this coming week. He said, "I want to know the names of the possible contemnors." There's a new word for you, right? Contemnors. Those are the people who have engaged in contempt. He said, "I want to know the names of the people who either did not or did get information about the order that I gave." And Mr. Ensign declined to do that. And the judge went on to say, "If I find probable cause for contempt, would the government like an opportunity to purge that contempt?" How do you purge that contempt? You reverse the thing that you have done that is wrong. And in this case, the purging the contempt would be to get those planes of immigrants back to the United States of America. In that connection, there was another federal district court judge, the fourth one identifying by name, because she too deserves your approval. Her name is Paula Zinnis, Z-I-N-I-S. She is in Maryland. You know about this story as well. While Judge Boasberg was doing that, she had a petition by a family of a Maryland man. His name is Kilmar Armando Abrego Garcia. He is all over the news. You know that well. Mr. Armando Abrego Garcia is a United States citizen, and he was put on one of those planes in error. And the Department of Justice and your government has acknowledged that, in fact, that happened. There are many times when I appeared in front of federal judges down here, and I said to the judges, Your Honor, on behalf of the agency that I'm representing, my client, we have made a mistake. We have erred. Let me take care of this. Let me remedy the problem, and that is what your Department of Justice should be doing, and taking care of this. In that connection, the Assistant United States Attorney who was appearing at that time in front of this particular judge in Maryland, here is his name, it's Erez Ruvini. He argued, number one, that there is a jurisdictional issue here, which is fine. We do that all the time. And then he went on to say that this particular individual, Mr. Abrego Garcia, should not have been sent to El Salvador. And asked why the U.S. couldn't simply ask for his return, Rufini said, the first thing I did, he acted properly. He said, the first thing I did, Judge Zinnes, when I got this case on my desk, is to ask my clients, the Department of Homeland Security, the exact same thing you're asking. And he said he did not get an answer. And Judge Ruvini, after all of that, late last week, ordered something to happen tomorrow. You know what that is. She has ordered that Mr. Abrego Garcia be picked up by our government, remedying, solving the contempt, and brought back here because he was improperly sent there, and she's giving them until tomorrow to do that. Likewise, Judge Boasberg has said, I am not satisfied by what the Deputy Assistant Attorney General has said to me. Likewise, I am going to demand this week that the Attorney General or other people give me the answers to the questions to which I'm entitled as a federal district court judge. I'm compelling you to provide that information, and if that needs to come from Pam Bondi, the Attorney General, if I need to get people into the court to swear to me what happened here, I will command that that will happen. And what is the point of all this, and why am I so animated about this, as you should be too? Because number one, your Department of Justice is not representing you today as it should. That's number one. And number two, hold on this week. Because in the next several days, Judge Boasberg and Judge Zinnes and other judges around the country are going to be faced with this fundamental issue. And that issue is just this. Is your United States government in contempt of court? And you might say, gee, that's a very nice legal thing for Jim Santelle to talk about. And yes, indeed, there are processes and procedures for civil and criminal contempt. All those things may happen. Indeed, that very well could happen. Judge Boasberg, in particular, wanting to know whose names he should put on the contempt order late last week. It is more than that, and it gets to the central issue that Shirley and I have been talking about, and your leadership as well, and that is, what are the limits of power? Because it's not just contempt. If Judge Zinnes and Judge Boasberg and the other judges find that your government is contempt, it's not just a judgment that gets filed in the federal district court. This is the open door, and the door is open right now to what is truly a constitutional crisis in America. The limits of this presidential power happen when a president, an attorney general, the representatives in court of the Department of Justice look at a judge and say, no, I won't do that. Watergate with Richard Nixon was not a constitutional crisis. Watergate, in the end, was resolved by Richard Nixon. We didn't think we'd be quoting him and supporting what he did back in the 1970s. Richard Nixon said, yes, Federal District Court John Sirica, I will turn over those tapes because you told me to do it. He didn't even think about the possibility of saying no. And he did, and it brought his presidency to an end, as we know. The system worked back in the 1970s. This coming week, we are tested again as a nation. And the question is whether or not my Attorney General, my President, the representatives in court will look at the judges and say no. And if they do, I will finally tell you, after holding back on any determination that we are in a constitutional crisis, that we have then come to the end of the checks and balances, right? There's no place else to go. Yes, indeed, as the Chief Justice said a few days ago, thankfully, there are appeals to all of this. But if we look to a judge and tell that person, I'm not going to follow what you have said, indeed, the things that are written in the Federalist Papers by our founding fathers are then meaningless. And we are on the cusp this afternoon, on this bright and wonderful Sunday afternoon, of exactly the constitutional crisis, and it could happen in a district court in Maryland, and it could happen in a district court in the District of Columbia. It could happen there, it could happen anywhere else. Some final comments about the powers of the presidency. You've got a piece of paper that Shirley and I put together for you. Just a couple of things about what the Supreme Court has said, and then what our president has said about the powers of the presidency, and the reasons why we've got an Attorney General and a Department of Justice today that appear to be looking at federal judges and saying, I don't have to follow what you say. We've got a border czar who has said out loud, Tom Homan, I don't care what the judges say. We're going ahead. I don't care about that. We know back on July 1 of 2024, 9 months ago, the United States Supreme Court said to you, establish the law of our nation, not only that a sitting president is entitled to certain kinds of immunities, but also the first 5 pages. And you've got some reference in that to the piece of paper that you have in front of you. The United States Supreme Court, at the hand of the Chief Justice, said that we need to have a presidency in this nation that is active, that is nimble, that is powerful and muscular, cannot be feeble at all, needs to react promptly and immediately, needs to do that in the indispensable nature of a president. Because if you have a feeble president, you've got feeble administration of government. That, I would offer to you on July 1, was an amendment to the Constitution of the United States of America. And we were not in the streets at that time because we hadn't seen it applied during the presidency of Joe Biden. During the presidency of this president, those words come alive, and they come from your Supreme Court. We should be outraged to this time about what the Supreme Court did 9 months ago. And on February 18th, just a few weeks ago, consistent with what the Chief Justice has said, the President of the United States of America issued one of these 50 executive orders. It gets lost in the headlines of all of this, but basically adopting what's called the unitary executive theory and saying that every single agency out there is beholden to me, including those that are independent, including the Federal Reserve, the Federal Election Commission, others out there. And along the way, he said this, it's in your paper specifically. He said, if there is anybody in the executive branch, anybody in government who announces a position that is contrary to mine on the law of the United States of America, they are doing that without my authority, and only I, the President, and the Attorney General can announce what the law is. He said that to you on February 18th, emboldened by what the Chief Justice said 9 months ago. And when he did that, he did, yes indeed, what Louis XIV said, l'état c'est moi. The state, that's me. He did what James I did and Charles I did. Charles I lost his head over this when he said, I don't have to abide by laws. I am the law. Your president said that on February 18th, supported by the United States Supreme Court. And that's the basis upon which he is entering all of these orders, and the basis upon which all of this is happening. All the good news, once again, is the bastions. There are lawyers out there who are doing good work inside the Department of Justice and outside the Department of Justice. There are also plainly federal district court judges who are doing this as well. You've got on that second page a great list of remedies that Shirley and I put together. Many of them are commonly known to you. I would offer to you, following up on the great comments made about what happened just yesterday throughout the state of Wisconsin and in our communities nationwide, that when millions of people get together and they say, we are not going to let you, Mr. President, exercise these authorities. There are limits. The federal district court judges are going to say no, and we're expecting the Department of Justice will likewise follow what you do. You are insisting by going out there in the streets that happens because that's your nation for 238 years. And that's what James Madison commanded. And I would offer to you one more thing that surely I have not yet said publicly at all, that depending upon what happens in that court in the District of Columbia this coming week and in Maryland, if your Department of Justice says, no, Judge, I'm not doing what you've been told to do, if that happens, there needs to be in America, here are the scary words, a general strike. Of the sort that the Israeli government, when Benjamin Netanyahu, prior to the Gaza war, wanted to change the Supreme Court and other judges there, what did the Israelis do? They shut the country down. You couldn't get into the Ben Gurion airport for days. They fled into the street and said no. Elective surgeries were prohibited. The academic institutions shut down. The businesses shut down. The Israelis said no. And indeed, the Supreme Court there supported them. More recently, just on Friday of this week, the Supreme Court of South Korea likewise said that the people, when they said, we're not going to tolerate the president establishing martial law in our nation, and responded back in December and continued to protest in the streets, shutting Seoul down, that the Supreme Court said, yes, indeed, you can do that. I wonder out loud today, if we are on the cusp of needing to do what South Koreans and what the Israelis have done, which is to establish a wonderful, wonderful exercise of liberty, acknowledging at the same time the consequences that come when we do this, but ensuring that our president knows that the things that he may be about, that our attorney general knows that they should be about, cannot stand. That's the commission we have today. It is a time of great excitement. There are reasons to be powerful and to be encouraged by the guardrails, but the guardrails are you as well. Last thing I will say is just this. On the side of the Department of Justice building, when you go there in Washington, D.C., are inscribed these words: before justice can exist in the conduct and the conscience of a government, before justice can exist in the conduct and the conscience of a government, must first reside in the hearts and souls of its citizens. That's you, and that's your Department of Justice. I am honored and delighted to be with you this afternoon. My colleagues and I will take your questions. Thank you so much. Thank you.
So this one's for Jim. What is happening if Trump refuses to follow court orders? I think we just heard this. When does the military get involved?
The answer is, if we still have a republic, the answer is the military should not be involved in this, right? The military is for a purpose. I was for 2 years in Iraq, very much engaging with them for foreign purposes. Our United States military is not a domestic force. We should not have martial law in this nation. Tried in South Korea, it did not work there. It cannot work here.
Okay, stay here. The next question is for Jim also. Can public health dollars that Trump is withholding from Wisconsin be restored by the courts? Does it have to go to the Supreme Court before the money must be released?
As all things that lawyers say, it depends. And it depends critically upon what a federal district court judge says. Again, all the judges are saying, yes, it's got to be restored. The question is whether or not those orders are stayed, suspended, pending further review. And the larger question then is, when it gets up to the Supreme Court, even if the timing is delayed, will this Supreme Court that has told you about this imperial presidency 9 months ago, will they say, we didn't mean that? That in fact there are limits to the presidency? That's the reason why letters to the Supreme Court and your advocacy publicly about what they can and cannot do should also be a part of your agenda.
Okay. So, Jim, is there any ambiguity in the Constitution about the necessity of the executive branch to implement whatever monies Congress has allocated? This is really a question about impoundment.
It is. And again, Richard Nixon tried that unsuccessfully, as you know. It's also a part of, frankly, this is really wonky, but all my colleagues up here are being wonky with me as well. And that is my favorite clause in the Constitution. It's the take care clause, right? James Madison put it in the Constitution. It says that the executive is obliged to take care that the laws of our nation including the state laws, be fully and properly executed. That is an obligation of the President of the United States of America. And that's the basis upon which, if he or she one day doesn't do that, we go in to enforce that particular provision of the Constitution. It is all dependent, again, upon what judges, including the Supreme Court, may say. Often get the question, can he do that, right? That's another way of describing this. And the answer is, as long as your Constitution, as long as the Wisconsin Constitution is in place, and we've got a rule of law, the answer should be no. The concern and the reason why we are gathered here today and in so many other venues yesterday and in the future, led by our wonderful leaders here, is we need to preserve the Constitution. If the institutions themselves fall in the courtrooms of the East Coast this coming week, and the Constitution doesn't mean anything to this president, and the legislature does not intervene to bring this president into line, and the courts fail to do it, then we do not have just simply a constitutional crisis. That's the time we do not have a constitution, and an authoritarian can do whatever he wants to do.
Okay, we have a couple more questions for Jim and then one for Deb Anthrock. Is there anything in the Constitution that allows the president to affect how elections are run? The president.
Terrific question. Shirley and I have talked about this. Of course, you know, among those 50 executive orders, the president does something that no, he cannot do, and that is he issues an executive order with his signature at the bottom of the page, badly written, full of typographical errors for what it's worth. But along the way, he says that in all federal elections, you are obliged to do many things, including show up with, yes, that's right, your birth certificate, right? There are many other provisions of that particular executive order. That's where this comes from. A couple of things that are important to note. You know this as well. You tell this to your friends and family as well. And that is that the president is the one person inside our federal system, James Madison stuff once again, who has no role in federal elections, right? We know that the Congress does. And we know that the states do, because what did James Madison say? He said he invested in our representatives right here to set the times, the place, and conditions of elections. And that's why our representatives make decisions all the time about things like drop boxes and IDs and those kinds of things. Elections, even federal elections, are products of state decision-making, not the president. And so the answer is, not only does he have no role in a federal election, he's the one branch of government that does not. The Constitution specifically says, Mr. President, it's in the state responsibility to make those decisions, and legislatively that can happen, not you. And yes, indeed, there are four different pieces of litigation going on right now in the federal district courts, including one from legislators, one from other parties out there, one from members of Congress who are saying you need to overturn this executive order as well. The judges, the federal district court judges, will do just that. We hope that when it comes to the Supreme Court, that John Roberts and majority there will likewise say there is no authority for a president to make those decisions and rob from the states the responsibility for state and, yes, indeed, federal elections as well.
Okay, I'm going to ask one more question that is, for Jim, that is basically asked 3 times in 3 different ways. So I'm going to read them all, and then you can answer them. What happens if Judge Boasberg is forced to hold the Justice Department in contempt? How do courts enforce rulings? And why should Trump's government obey judges when Trump can pardon any of them? They're all the same question.
They're all the variations on procedure, right? Here's the law school portion of our gathering today. Let's think about what happens if Mr. Ensign, who is right now the only name that the judge has in front of him, if the Judge Boasberg, says, you're not giving me names. I know there's a woman named Pamela Bondi. I know that she is the Attorney General. I know there's a fellow named Todd Blanche, who is also, by the way, responsible, believe it or not, for firing just yesterday the other Assistant United States Attorney in front of Judge Zinnes, who was honest with her and told her, I don't have a good answer from my very agency. the Deputy Attorney General, your Deputy Attorney, fired, basically put on administrative leave, that Assistant United States Attorney. Shocking as well. What does the judge do? He's got remedies. Civil contempt, criminal contempt, we won't go into all the details. Here are the remedies. You can impose litigation sanctions. You can say, government, you cannot do certain things inside this litigation as it goes forward. Restrictions on producing discovery, getting discovery, all kinds of things you can do inside the litigation. That sounds fairly weak, does it not? You can impose fines as well upon a litigant, including a fine penalizing, can you imagine this? The United States Department of Justice. And yes, indeed, here's the big one. You can jail someone who has been found in contempt. You can send them into the custody of federal authorities until that's the reason why the judge said, do you want to purge your contempt? The way you do that is you send a message from the jail to the judge that I'm prepared now to do the thing that you told me to do from jail. Judges can do that. Who knows what Judge Boasberg, he is very, very ponderous about these things. He's very good. But there is a possibility, there is a prospect procedurally, that a federal district court judge could look at the Secretary of Homeland Security, could look at the Attorney General and say, you are in contempt, and my sanction is incarceration. Could you imagine that in America of 2025? There are things that can happen, and this government also can purge itself of that decision not to follow up.
Well, thank you, Jim.
Good.
That was a really good lesson in our democracy and the rule of law. And now I have a question for Deb Andraka. What sort of response are you getting from Republican legislators on the subject of gun-related legislation?
Not much. There are a number of gun safety related provisions that are listed in the governor's budget. We put them in over and over again. They are routinely taken out. Because this budget is hopefully going to be a little bit different, hopefully we'll see a little bit more negotiation, but we don't know. In years past, they've taken the governor's budget, thrown it out, start from base, build their own. So there are a lot of purple legislators who really need to be on the correct side of this issue. And I have been talking with a number of them behind the scenes on a couple of suicide prevention specific legislation. I texted them right after the election and asked them why I haven't heard from them. I got a text back saying that they're still thinking, and I needed to be patient. My patience has run out. We will be working on this as soon as possible. If they toss these laws out, or these proposals out of the governor's budget, they will be introduced, and we will keep introducing until we can get them passed.
Thank you. Oh, Mark, that's right. So, Mark Gennis, our membership co-chair. Thank you.
Yes, Mark Dennis, I co-chair the membership committee along with Kath Michelle, who's out there at the membership table. I think what we've heard today is it is the best of times, at least here in Wisconsin, and the worst of times, given the state of the nation. You may recall last week in Green Bay, Elon Musk made this comment 2 days before our Supreme Court election, quote, "I feel like this is one of those things that may not seem that it's going to affect the entire destiny of humanity, but I think it will." Well, you know, Elon, so do we. What we as progressives need right now, while still keeping in line with Trump's DEI order, is a white knight on a white horse with white horseshoes and a white suit of armor, carrying a white lance. Looking at the results from Milwaukee and Ozaukee County, we already have our knight. And ours comes in a full array of colors, creeds, and sexual orientations, and our knight is Grassroots North Shore. And if you want to be part of the fun, please stop by the membership table at the reception area and join us. we've been very fortunate so far not to have a tariff slapped on Grassroots North Shore. So our annual membership fee remains only $30 for a family, $20 for an individual, $5 for a student, and donations are always welcome. I want to read this very prescient quote from Louis Brandeis, which seems particularly applicable to our horrible situation in the country today. Quote, "We can have democracy in this country, or we can have great wealth concentrated in the hands of a few, but we can't have both." And I want to give a big thank you to all of our great speakers, Greta Neubauer, Deb Andraka, Jody Haber-Sinnigan, and James Santelle. Jim will be available for questions in the reception area, where you can also enjoy wonderful cookies and treats. And please keep these upcoming Grassroots North Shore events in mind and mark your dates and calendar. On June 22nd at Doctors Park, Grassroots will be holding a volunteer fair group called Wisconsin Cares to showcase those who are working to make our lives, our nation, and our planet better. And on September 8th, Grassroots North Shore will be holding our 20th anniversary celebration. Not to be missed. And stay tuned for further information. And a final thank you, I promise, Shirley. I want to thank the young woman who is carrying the sign at yesterday's rally, which simply read, "IKEA has better cabinets." Thank you.